but I'm going to start with this. The judge says, listen, an omnibus motion, which means that it contains two or more independent matters in one motion. So the different things that the defense raised, according to what just happened in court, was number one, a motion for continuance, number two, that he be released on bail, number three, that there be a hearing on due process, and the fourth was that he received medical treatment, because the defense is saying he's an AFib but not receiving medical treatment for that. The thing I want to hone in on first, because the judge made a very good point, the defense apparently provided all kinds of medical records, and I even hear the defense attorney say we went to great lengths to get these detailed medical records, and the judge said, okay, but you just gave us notice 2 days before trial started. 2 days before trial started, we get notice that you're requesting a continuance. California statute requires 10 days notice. If you're getting all these medical records, then ostensibly you could have given us at least 10 days notice. What do you think?
In California, you just need to give 2 court day notice for a motion to continue, which is a 1050 motion. He's okay as far as the motion to continue, and the judge kept on saying that. He said, you've got no problem with that. You've given us a 2-day notice. He filed the motion on Thursday, which gives you Thursday, Friday, and today is Monday. He's fine. He's safe there. And I guess the judge had a tentative on that, and that was a denial, but it's not final. He could still hear arguments and decide based on that. But it sounds like it's an omnibus motion with a lot of attachments and evidence and declarations by doctors, and it would require some time. It may require some testimony. But the problem he's having is really with the other 3 motions. 2 of them, the judge based for all 3, he needed to give a 10-day notice, and those are just regular 10 days. And clearly he hasn't done so. The judge is saying, listen, if you wanted me to hear these 3 other motions in a short time period, you had an option. You could have just filed a motion to shorten time, and he did refer to the local counsel saying, you know, he knows this. He knows about the rules here, and he should know that you should have filed these other 3 motions 10 days ago and given us basically the 10-day notice, including the prosecution, and you haven't done so. He also mentioned very quickly about the motion for the hospitalization, saying that the court doesn't or may not have jurisdiction there, and I understand why he's saying that, because he's in the custody of the sheriffs in a jail, and they decide if he's going to go out. A lot of times they have more jurisdiction. I mean, the defense can make the argument. Maybe the judge will consider it based on case law, but generally the reason he mentioned that is because he is in the custody of the sheriffs, and they could take him to a hospital if need be.
So I want to just confirm what I just heard you say to make sure that I understand in California. So the motion to continue, 2 days notice, the judge says, I'll consider that. On the other 3 motions that do require the 10 days notice, and I think everybody could agree that they did not provide 10-day notice, under California law, does that mean those are automatically dismissed, or rather is it in the discretion of the judge to decide what to do?
They're not dismissed. He just needs to give the 10-day notice. So in other words, they could either be heard in 10 days from the date it was filed, or they can file a motion to shorten time. They have to explain why it is so urgent for all the parties involved to hear these motions within less than the 10 required days of notice, which he hasn't done either.
All right. Thank you for clarification. I'm so happy that you're joining us and can help us understand. As we all know, every state's laws can be a little bit different.